And let's go ahead and kick off the Monroe County Special ROGO Workshop. It is, oh, it's 10:01. I did gavel in at 10 a.m. Just want to note that for the record. Let's go ahead and do the pledge. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, and before we get started, I do have to make a really quick announcement. Clerk Kevin Maddock is at the Clerks Winter Conference in Jacksonville, Florida, so he will not be in attendance today.
And we wish him well. Safe travels. Thank you. All right, additions, corrections, and deletions.
We don't have any.
Phenomenal. All right, before we do get into our business for the day, I'd like to us and say hi. Welcome to the Keys, by the way.
Mayor Meryl Rasheen, members of the County Council, Commission rather, thank you very much for having me today and the warm welcome. I'd like to recognize that in my 30 years of municipal government experience, which has involved substantial intergovernmental in that regard, so a lot of credit to you, to Manager Gastesi, and the team that provides that level of support for the communities that fall under your umbrella, including Isla Mirada. Really, that is the extent of my comments for today. I'm ecstatic to be in the Keys, and I'm looking forward with great anticipation to working with your team and helping to advance our shared goals.
Oh, that's wonderful. And we're ecstatic to have you, and you're about to have a crash course in development in the Keys.
Yes, thank you.
Game on. All right, thank you. Commissioners, any comments?
Just welcome to the Keys.
Good, good. Yes, round of applause. Yes, he deserves it. Okay, Madam Clerk, let's go.
Okay, and before we move on, can I get a motion for approval of the agenda?
Move to approve.
Second.
We have a motion by Commissioner Lincoln. We have a second by Mayor Pro Tem Scholl. Motion carries.
Got it. All right, so your first item is item B1 on page 2 of your agenda, presentation on taking law by Senior Assistant County Attorney Derek Howard.
Good morning.
Good morning.
You're recognized.
Thank you. So I'm Derek Howard. I'm a Senior Assistant County Attorney in the Monroe County Attorney's Office. The purpose of my presentation today is to provide an overview of regulatory takings in Monroe County, quell some misconceptions about that area of law and the county's overall takings liability, and to hopefully inform both the public and the board as it makes important decisions with respect to the rate of growth ordinance and allocations. So I've been with the County Attorney's Office about 15 years now, and been handling Monroe County land use and regulatory takings cases for even longer, including my time as outside counsel. Kind of known as the regulatory takings guy. That might make some people wonder, well, what is a taking? And a taking at its core is a continuing physical occupation or ouster of private property or a deprivation of all or substantially all economically beneficial use of property. Its origins are obviously in both our federal and state constitutions. The Fifth Amendment includes what is commonly referred to as the Takings Clause, that essentially states that private property cannot be taken for a public use without just compensation. Article 10, Section 6A of the Florida Constitution also has its own sort of takings clause, and it basically substantially mimics the federal provision. It's important to recognize that these provisions do not in and of themselves prohibit the taking of private property or even require owner consent, but puts conditions on the exercise of the government's eminent domain power. In one landmark case, First English, the U.S. Supreme Court stated that the takings clauses are not designed to limit governmental interference with private properties per se, but rather to secure compensation in the event of otherwise proper interference amounting to a taking. So there are many types of takings. There are first physical takings. This is where the government may occupy private property or oust a property owner from their private property. This includes intentional use of the property by the government. This might be for the installation of utilities, the construction of public roadways. It might include like a navigational servitude over a private marina. And then also in Florida, you may have heard of the citrus canker cases. That was where the state went in and destroyed healthy citrus trees in order to prevent the spread of citrus canker. So that would be an example of a physical taking. There's also loss of access takings. This might be where the government puts up concrete barriers that prevents a person from accessing their property via a roadway. There also might include impairment of private roads by virtue of some, government action. And there's also recurrent flooding. This is where, the government perhaps did something that causes, drainage onto private property. If it's recurrent, the courts will look at a number of factors to determine whether that's a taking. Regulatory takings. I'm going to get more into the meat of regulatory takings here shortly. And then there are temporary takings. Both physical and regulatory takings can be temporary in nature. Finally, we have in Florida what are called Burt J. Harris Act claims. These are not necessarily taking claims, but they are a statutory remedy for claims of inordinate burdens that fall short of a taking. So regulatory takings, there are two types. There's a facial taking, which is also known as a per se, categorical, or Lucas taking. The reason why it's sometimes referred to as a Lucas taking is because the U.S. Supreme Court, provided, the standard for these types of takings in Lucas versus South Carolina Coastal Council. This is where you have a total elimination of the property's value. 100%. If it's anything less than 100%, then that's not a facial taking. Facial takings occur upon the enactment of a regulation. An example would be, not that I think we plan to do this, but it would be a new ordinance that categorically and permanently prohibits new development. We say in an ordinance that we are not going to issue any more ROGO allocations. That might invite a facial taking claim. We also have as-applied takings. This is where you have something less than the total elimination of economically viable use when a regulation is actually applied to the property following a development application or something of that nature where the applicant is asking for something, and then a regulation might be applied that prohibits development or accomplishes another limitation of property use. In these types of takings, we do an ad hoc factual analysis specific to the circumstances of the particular owner. The first thing that we would look to is the economic impact of the regulation on that owner. We would look to the extent to which the regulation has interfered with the owner's reasonable investment-backed expectations. And these are expectations that are held at the time of purchase. You can't buy property, with the intention of, let's say, building a home and then changing your expectations over time to meet, your needs of the day. The court looks at, well, what did you buy this property for? What did you want to do with this property? The third factor that's examined is the character of the governmental action. And again, an as-applied taking requires at least one development application and a final decision from the government. So you may have heard the terms eminent domain and inverse condemnation. The distinction is that an eminent domain proceeding is one that is instituted directly by the government in order to acquire the property. In Florida, we have both a quick take and slow take statute. These just provide different procedural mechanisms by which the government can directly condemn property. What you probably are more familiar with in Monroe County is inverse condemnation. This is where a legal proceeding is instituted by the owner of the property to recover just compensation for a taking by way of regulation or other action when condemnation proceedings have not been instituted. Now, there is a bifurcated process.
Derek, excuse me 1 second. Can everybody please silence their cell phones? It's kind of serious information. Just double check your phones. Thank you. Go ahead, continue.
Thank you. The first phase is a liability phase. This is where we ask the question, was there a taking? This occurs pursuant to a bench trial before a judge. And the interesting thing in Florida is that only the owner has the right to appeal the decision if they lose. If the government gets an adverse liability determination at this stage, it would need to wait until the conclusion of the second compensation valuation phase in order to appeal that liability determination. So the second phase, the compensation or valuation phase, that is the question, what is the fair market value of property? This is determined by a 12-person jury, and following that proceeding, both sides can appeal any issue. So damages for inverse condemnation must be the same sort of outcome that the owner would have received if the government had actually instituted direct condemnation proceedings. The first form of damages for a permanent taking would be the fair market value of the property on the date that the taking began, plus statutory interest until the compensation is actually paid. Upon payment of that permanent takings compensation, the government then takes the title to the property. Now, if the temporary is only permanent, then the damages would be only the statutory interest on the fair market value of the property for the period of time that the taking was in effect. Another form of damages would be court costs. These would include such things as, deposition transcripts, trial transcripts, appraisal fees, expert witness fees. So, the owner, if they prevail in an inverse condemnation case, they would recover all of these costs from the government. Finally, we have attorney's fees. Now, in takings cases, these can be quite exorbitant. However, there is a statutory provision that allows the government to limit the award of attorney's fees to the percentage of benefits that the attorney achieved for the client. Now, benefits means the difference between the final judgment and the first written offer that the government made, if they made one, after the owner hires an attorney. It's 30% of any benefit up to $250,000, plus 25% of any portion of benefit between $250,000 and $1 million, and then 20% of any portion of benefit exceeding $1 million. So, this mechanism allows the government to have more certainty in terms of what the cost of the litigation might be and making a decision whether to proceed with, defending itself or settling. Now, an example of this would be Galleon Bay. I think everyone in this room has heard of Galleon Bay, which I'm very happy to report that appears now to be fully concluded. In that case, the government, the county, made two written offers. There was one for $835,000 in 2001, and then another one for about $1.5 million in 2003. Now, both of these offers were actually more than the final judgment of approximately $500,000. So we argued, zero benefits were achieved for the client by the attorney, and we therefore did not end up paying any fees in that litigation pursuant to a settlement agreement. So it's an important mechanism that should be kept in mind if there are any future takings cases, and I'm guessing that there may be. The next issue is, when is a regulatory taking claim ripe for litigation? Basically, ripeness just answers the question, is this case ready for a court to review? Facial claims are generally ripe upon the enactment of the complaint of regulation. The owner doesn't have to do anything else. It can just say, well, this regulation categorically eliminated value of my property, so they can go right to the courthouse. If, however, it's an as-applied claim, then generally the courts will require at least one meaningful application for development approval, a final decision on that application, and then, of course, exhaustion of any administrative remedies that might be available to that owner. We're special in Monroe County, as we all know. In Monroe County, regulatory taking claims, both facial and as-applied, only become ripe after a beneficial use determination is completed by the owner. Our code, section 102-102, allows an owner to, come to the Department of Planning and the board and say, this regulation took my property, and this is the relief that I want. And there's various forms of relief that can be extended to the property owner under this process. There can be an offer to purchase the property. The government can, waive, variances, setbacks, discontinue the regulation. But the threshold that the owner must establish is that a court would likely find that a taking has in fact occurred. Now, this was at issue in our Collins litigation. This was litigation that involved 11 sets of plaintiffs. We prevailed as to all sets of plaintiffs except for Donald Davis. In a court decision, I'm just going to read this because I think it really highlights this process. The court said the Monroe County BUD ordinance itself answers the ripeness question. The BUD ordinance was designed as a way to avoid constitutional taking lawsuits by providing other means of compensating for total or partial regulatory loss of economically beneficial use of property. In this way, the BUD differs from land use regulations in other jurisdictions in that it accounts for both facial and as-applied takings as seen in its bifurcated relief of either outright purchase of the property, in the case of a per se taking, or grant of transferable development rights, rate of growth ordinance points, variances, and building permits in the case of an as-applied taking. Once the BOCC rendered a final decision on the BUD applications, the landowner's claims became ripe. We had in that case asserted that the statute of limitations in fact ran prior to these owners getting their BUD determinations. In this particular case that this language is coming from, the third district said no, it was not until they sought BUD relief that their claims became ripe. Now, the court did note, let me just back up, facial challenges generally face an uphill battle. This is something that's been recognized by both the U.S. Supreme Court, Florida courts, but this is especially true in Monroe County. And the third DCA went on to importantly state, quote, where the land use ordinance, in this case the BUD ordinance, leaves open the possibility of reasonable use, a facial challenge will likely be unsuccessful. That's very important language, and I think speaks to the thoughtful design of the BUD ordinance, because it does go to both facial and as-applied claims, and it's a way for the county to, all right, do we perhaps have liability with respect to this particular case? And if it's concerned about its liability, then it can grant relief. And again, the array of relief that can be granted is pretty great. So I had mentioned that there's another set of sort of takings-like claims that are known as Burt J. Harris Act claims. This is a statutory cause of action that was adopted in 1995 for government action that inordinately burdens either an existing use or a vested right to a specific use. The statute excludes temporary impacts to property. It excludes inordinate burdens of uses that might be deemed a nuisance under common law. It also excludes regulations or government action local government action that is required to enforce a federal regulation such as the Endangered Species Act or the Clean Water Act. We know these acts very well in Monroe County. The good thing about the Burt J. Harris process is that it requires a 90-day notice period to government before filing a claim in circuit court. It allows the government to settle the claim through a number of means. This might be, modifying the regulation, issuing a transferable development right, allowing the swap of the subject property with another property, issuing development approval or purchase. So the forms of relief under Burt Harris are, some of them are the same forms of relief that we have under our beneficial use determination ordinance. We do have experience with Harris Act claims in Monroe County. In 2008, there were 41 petitions that were filed relating to 81 vacant lots, alleging inordinate burdens based on the adoption of the tier system. We know that the tier system, classifies property according to, 3 tiers. Tier 1 is the most environmentally sensitive land, and we try to steer development to, tier 3 properties. So when this new system was adopted, these folks argued that their properties were inordinately burdened. We responded immediately that the petitions they submitted did not comply with the statutory notice requirements because the appraisals did not make a required showing of the alleged loss of fair market value. And this was because the properties were valued prior to the adoption of the tier system. They erroneously assumed that building permits would not be possible. They excluded a consideration of other uses in addition to the residential use that the owners wanted, and they excluded consideration of other applicable state and federal environmental regulations. When we do appraisals for Burt Harris claims or takings cases, it's not an opportunity for the property owner or even the government for that matter to live in a fantasy world and just to make any types of assumptions that it might want that would further its goal, which in the owner's case might be to drive up the fair market value of the property, or in the government's case to drive it down. You have to the appraisal actually has to consider the real conditions that are out there. So when we responded to these petitions in the way that we did, the petitions were never subsequently pursued. I would note, however, that some of the petitioners went on to become unsuccessful plaintiffs in separate later inverse condemnation actions against the county. We also had a petition that was filed in 2008 by Lloyd Good, who alleged an inordinate burden of his lower Sugarloaf Key property based on the tier system. That claim was, in fact, filed in circuit court after the 90-day notice period, and then it was later dismissed. So Emily, after my presentation, she is going to give a presentation on the number and types of vacant lots in Monroe County, speak to more background about the rate of growth ordinance and the issue with allocations, what we have left, and what we might need. I'm going to let her do that. The burning question that everyone might have in this room: is there takings liability for every vacant lot in Monroe County? And the answer is no, there is not liability for every vacant lot in Monroe County. And that's for a number of reasons. The first is that, we have a lot of defenses to regulatory takings claims. These are defenses that are, generally available across the jurisdictional board, but ones that are, very carved out at this point in time in Monroe County. The first thing that you would do when you get a takings case is you would ask the question, well, has there been a taking? The first thing that you would do is you would look to see whether there are any other economically viable uses of the property. This is under the economic impact prong of Penn Central. Now, the standard here is not, whether the property owner can do what they want to do with the property. The standard is whether they can do anything with the property that gives it value. And we look at, as a focus for this inquiry, the fair market value of the property, because that will actually tell us whether, there is some market valued, thing about this property that would indicate, well, there's still, you might not be able to do the thing that you want to do, but there's still value with respect to other uses. For example, does a property have ROGO dedication lot value? We know in Monroe County we have a very active secondary market of, ROGO dedication lots. People, swap these types of lots in the private market all the time. And, if a property has this type of value, then, there's still, that's a use. Another use might be, its TDR value, or, its recreational value, its value as, for accessory uses. Maybe you can build a pool that might enhance, your neighboring property, and sale of property. Again, if the property is being sold and people are paying something for the property, that's a pretty good indication that, there's still, property value. The next thing that we would look to is, what were the reasonable investment-backed expectations of the property owner at the time of property? Now, again, the expectation that you might have at the time of purchasing the property has to be reasonable. That's the first threshold showing. But then we look to, what steps have you actually taken to develop the property? This was squarely at issue in the Collins litigation that I referenced earlier. The court, found, and I quote, the landowners did not take meaningful steps toward the development of their respective properties or seek building permits during the sometimes decades-long possession of the properties. Monroe County was designated as an area of critical state concern in 1979, but the first land development regulations were not enacted until 1986. If landowners did not start development prior to the enactment of these land regulations, they acted at their own peril and relying on the absence of zoning ordinances. So, what the court is saying here is, we're in Monroe County, we're a heavily regulated jurisdiction. Everyone knows it. It's very difficult to go through the development process here because it has to be. I mean, we only all of the many issues that we deal with in this jurisdiction, which are complicated in Monroe County, necessarily so than it is in any other jurisdiction. Either know this or you should know this. So you've got to if you want to develop, you just can't sit idly by and do nothing. Interestingly, the Collins Court looked to the property owner in the Galleon Bay case as a, quote, suitable contrast to the landowners in Collins. And they noted that in Galleon Bay, over decades, they spent hundreds of thousands of dollars, with various development efforts, including replatting, rezoning, negotiating, building permit applications. I mean, that is one thing that, there's no doubt. Galleon Bay really, they tried, and that to the courts, the third DCA meant something. The other thing that we would look to is, okay, well, is this allegation of a taking just based on a reasonable delay, for example? I mean, we know ROGO, the whole, point of ROGO is to, distribute the allocations that, the state of Florida allows us to issue each year. And we do that based on, a competitive point system that, awards various points for applicants, a number of things that we've built into the rate of growth ordinance. And so, it takes time, and that's okay. The first district, has held that the timetable for developers, quote, must anticipate delays, whether occasioned by holdups in the permitting process, litigation by neighboring landowners, or a temporary development injunction or moratorium. Close regulation by local government that is merely expensive or time-consuming for developers does not arise to a taking. So there are timing defenses to takings claims. These essentially, ask the question, did you bring the claim too soon? This might be where, you didn't pursue a beneficial use determination process, or did you bring it too late? Regulatory taking claims, inverse condemnation, they are subject to the 4-year statute of limitations. And again, if it's a facial claim, that 4 years begins to run on the date that the regulation was enacted. For the as-applied claims, it accrues when the complaint of regulation has been applied. So third-party defenses. This is something very important in Monroe County. Liability for takings flows up the levels of government and not down, where state agencies or federal agencies exercise superior jurisdiction that might preclude development. I wrote a pretty comprehensive article on this topic for the Environmental and Land Use Law section, Florida Bar Reporter. And in that article, I talk about how Monroe County is probably the most complex regulatory jurisdiction in the nation, and that's because of the interplay of a number of federal, state, and local laws and regulations that go to our very rich aquatic and terrestrial resources. So what we do when we get a takings case is we ask the question, well, is this really the liability of Monroe County, or is it perhaps liability that should exclusively be bared by a state or federal agency, or perhaps jointly? And the reason we do this is because we don't, of course, want Monroe County taxpayers being unfairly burdened with the cost of protecting resources that are regionally and nationally important. With respect to the state, the state might have exclusive liability pursuant to the Area of Critical State Concern Oversight or Environmental Resource Permitting Authority. We successfully brought the state in as a third party in the Galleon Bay and Collins litigation. The state has since that time been a partner to Monroe County in defending against takings claims and paying 50% of the judgments. A lot of folks don't know this, but I regularly interface with the Florida Attorney General's office. We coordinate defenses of litigation where we're both named plaintiffs. The state will sometimes ping our office to request support, research support, or we've got this case. How any advice on how to handle this. We see this with Key Haven versus the Department of Environmental Protection, DEO, and Monroe County. That was a case that the owner alleged inverse condemnation of 5 partially submerged lots in the Lower Keys based on the state's denial of ERP permits to fill the lots for residential development. They were told that, in addition to, the state regulations, that the state had considered, some of the comprehensive plan policies and regulations of Monroe County. We have not allowed the filling of submerged lands in Monroe County for well over a decade. We argued, well, this is not our liability. The regulations that you deny these permits on, those are within your own control. And so the court fortunately dismissed the county as a party in that litigation. We're no longer a party, but we still continue to provide support whenever asked by the Florida Attorney General's office that continues to litigate this case in court. Then federal government, we've got the Endangered Species Act, the Clean Water Act, the Coastal Barrier Resources System regulations. Folks might remember this very well when, Fish and Wildlife was and FEMA, when they were sued by an environmental group and alleged that, FEMA did not coordinate with Fish and Wildlife with respect to the implementation of the National Flood Insurance Program in Monroe County. There was that very encompassing injunction against the issuance of a new federal flood insurance for any new development that was, during that period of time, development kind of grinded to a halt here in Monroe County if you were on that injunction list. So demonstrates like all of the, the interplay, of state, local, and federal laws. In Galleon Bay, we successfully argued that these regulations were obstacles to development that adversely impacted the fair market value of the property, and that, ultimately drove down the compensation that was awarded to Galleon Bay. We also have a nuisance exception defense. This defense is still, taking shape in the courts. The general rule is that, no owner has a compensable expectation to use property that constitutes an injury or nuisance to others. There are still a lot of unanswered questions with respect to this defense. One being, is the public harm created by overdevelopment and its impact on hurricane evacuation and safety, a nuisance? Is the filling of submerged lands in the face of sea level rise a nuisance? This was raised by the state in the Key Haven litigation.
Hey, Derek, Commissioner Cates has a question for you.
Please. Yes, while you're on this, discussing this, how would it come into play, a harm to others, as you said, public safety, when the evacuation model is 24 hours for the amount of ROGOs that we are allocated now? And when that comes to an end, can somebody sue because they want to build, but that could create harm, life safety issues for the rest of the residents because we can't evacuate in time?
Yeah, I think that is an argument that could be flushed out. I I would caution that the law is not there now, at least under this particular defense. I mean, there would be other, of course, defenses that I've already discussed that could be asserted as to a claim given, the facts in that scenario. But, I'd make the argument, but there's I wouldn't hang your hat today on that argument. But, it is something that's being flushed out. My academic opinion is that, as environmental threats continue to arise and worsen, and the individual impacts become more important in the aggregate, and that might be like the one more permit that puts the one more car on the road that brings evacuation under over 24 hours. That all of that is going to become more important, and that the courts might come to find that private individual development that constitutes an environmental harm or public safety harm is a nuisance that the government shouldn't have to pay for.
All right, thank you. I just wanted to touch on that.
Yeah, actually, I meant to say before, I prefer conversations as opposed to lectures. So if you have any questions at any time, I really invite you to speak up.
I think we're just taking it all in.
Okay, I know it's a lot to take in. So moratoria. This is, at its core, a land use moratorium is a temporary suspension on the issuance of building and/or other development permits, essentially to allow the government to maintain the status quo and to study whatever issue it's sort of grappling with. And what the government is saying, okay, during this period of time that we're figuring this out, we're not going to issue any more permits. It's just a hold, a pause. We have historically used this as a tool in our earlier years of planning following the state's adoption of comprehensive planning requirements, and then the 1979 designation of the county as an area of critical state concern. There were periods of years in the early years that we had a number of moratoria in effect. Some were, Big Pine Key. There were concerns about the level of service and, the increased infrastructure that would be needed by, this new development. So that's what moratoria is. I will say, well, let me first get to maybe another burning question. Well, is that a taking? It's not. Reasonable temporary moratoria is not a taking. This was the holding in Tahoe Sierra Preservation Council. The TRPA, in that case, they adopted a development moratorium covering 32 months to maintain the status quo as they grappled them. Yes, Commissioner.
I have a question. Thank you. Thank you, Madam Mayor. So is it possible then that instead of us lending Marathon temporary building rights in Marathon instead of us lending them units?
Absolutely. I think that my opinion is that under those facts that a moratorium would be, it would be appropriate and, would be defensible. It's not a permanent ban on development. They're not saying, well, never going to, just for the time being while we, figure out how to proceed in the face of, the shortage of allocations, while we decide what we want to ask for, from the state, coordinating with its partners, Monroe County. And under those circumstances, a moratorium, I think, would be perfectly defensible. It would not be, a taking. I think, when you look at the factors at play in Tahoe Sierra, and then also a number of Florida state court decisions that where other local governments in Florida imposed moratoria for a number of reasons. You would look at a number of factors to determine the reasonableness of the moratoria, like its duration. Is there a valid public purpose? Did the government promptly and in good faith try to respond to that issue that it's saying it's basing its moratorium on. I think, when you apply those factors, I think that, yeah, it would be an option that would be available to the city of Marathon. Is that helpful?
It is. I hope our partners in Marathon are on this Zoom because they aren't here in the room.
It is. I know there's a big misconception out there that moratoria invites takings liability. It might if it's unreasonable, but if it's designed, thoughtfully, no, it's doesn't invite automatic takings liability.
I wonder if that would be cleaner for us than trying to lend them units. Something for us to think about.
Well, that's why, that's why I'm giving this presentation, so that you guys have good information and background to make, these decisions that I know you have to make. So just to give you a total, paint the picture of where we are, where we have been by the numbers. Since 1987, we have had 58 approximate takings in Burt Harris cases or petitions. The vast majority of these cases and petitions involved multiple lot owners, class actions. It's really a lot more than 58. I would estimate that there were hundreds of lots that were at issue in these cases or petitions. We only have one remaining pending claim against the county. I'll speak to that very briefly in just a minute. And then we have one beneficial use determination application that was just filed last month. This will eventually come to you to decide what to do with that, but it needs to go through a process before a hearing officer at the Division of Administrative Hearings first. We prevailed in all cases or petitions except for 5. Gonzalez in 1991, in which the county paid $75,000 for both compensation and attorney's fees. Shattuck in 1995, it was filed in 1995, it was settled for $5.9 million. I'll just say, I think Bob might want to weigh in a little bit about this case. This was during the early period when the county was still getting its sea legs with respect to land use regulation, responding to all the requirements from the state, comprehensive planning requirements, and then of course our area of critical state concern designation. I mean, now, it's amazing how sophisticated the county has become in its regulation and its agencies that respond to the many issues in Monroe County. But this was during a time back in the day when we were still figuring things out.
Yeah. Shattuck is an interesting case. It's one where the state left us hanging out to dry. The state asked us to impose a moratorium while they were negotiating on some acquisition. They didn't want the development to move forward. The state eventually purchased the property from the Shattuck family, but in their purchase agreement, they forgot or didn't think to get a release for the county for the temporary taking. So the Shattuck family sued. Date is interesting. It was late 90s before the Tahoe Sierra case came out to define the temporary taking of 32 months, 36 months, 32 months.
32.
Whatever. Almost 3-year moratorium was not a taking. We were about that, maybe a little bit longer. I don't know if Shattuck would have been decided the same way today after the Tahoe Sierra case came out. It came out, the county had a liability. I came to the office in 2000. This was settled shortly after I came in, and speaking to Jim Hendrick, who was the county attorney at the time, and Jim Roberts, who was the county administrator. They explained to me that, yeah, they had estimates of liability between $5 and $50 million. County commission at the time were looking to put in sewers and other capital projects and said, wow, a $50 million judgment on our books would hurt our bonding capacity as we try to do these other So as we try to do these other projects. So they made the decision to settle. The Shaddocks were gracious enough not to be seeking the maximum. They thought the low end, the amount that was negotiated was fair. And they agreed to take it in 3 increments so that we could break it up over 3 budget cycles. So that's been our biggest loss to date. It's kind of awakened everybody. It started a long conversation with the state about a partnership agreement, which kind of culminated with some decisions that were made in the Bush administration when Governor Bush was running the cabinet. But again, I don't think it would have come out the same way, because we didn't go to trial on valuation. We settled it. It wouldn't go to trial. It would not come out the same way if we had the benefit of the more recent cases from the U.S. Supreme Court. So yes, it's a big number. It was a big number today. It was a big number 20 years ago. But you have to understand the facts surrounding it and not get spooked by Shattuck.
I agree with that. We've gotten a lot better litigating takings cases since Shattuck. And again, part of that is because we have more favorable case law. I would say that collectively, the 58 cases sought a couple $100 million in compensation. The approximate total that the county has paid out is close to $7 million. As you know, we paid a judgment in the Galleon Bay litigation for about $530,000. They sought well over $10 million. And I would note also that in that case, the county took title to 7 lots, and so we were able to retire development rights as a result of that judgment. Davis was the only one to prevail in that. The total judgment was less than $400,000. When they filed that case, collectively they stated that they were seeking approximately $24 million. So takings will always be a thing in Monroe County. I mean, this is like that comes with the types of regulations that we have. But to date, I think the takeaway is that it's a manageable risk. I have a slide here that talks about the regulations that have been at issue in some of the cases that have been filed. In the early years, it definitely was all about the moratoria, and then I would say that for the period in about 2000 became like sort of more regulation specific, wetland regulations, the rate of growth ordinance, tier system, and then various Endangered Species Act issues, and then of course we in 2024, vacation rentals seem to be kind of the thing now. I'll get to that in just a minute. I believe that this slide presentation is going to be made available to the public. I did go through, I did a comprehensive pulling of all the cases that have been filed against Monroe County and the Burt Harris Act petitions. I'm just going to flip through these. I don't think that we need to really talk about any specific case unless you see one that you'd like to discuss. Well, there is the Emmerich case. This is, I will just real quick, because we do have the BUD application that was recently filed, and that concerns Ocean Reef property. So did the Emmerich case, and that involved the application of the county's red flag wetlands that reduced the buildable footprint of that property to approximately 1,800 square feet. The Emirates argued that that was not reasonable, that they should be allowed to build a larger size home, that was their expectation. Well, the court found that the ability to build a house within, 1,800 square feet, that's not a taking. They sought, over $1 million in compensation for that claim. We actually, because we prevailed, we collected, I think it was $40,000 in costs from the Emirates. Galleon Bay and Collins, unless you guys have any questions, I'm just going to flip through those. I think you've heard enough about Collins and Galleon Bay. These are the cases between the period of 2004 and 2009. And then 2012, taking us to the Key Haven litigation that I referenced. This is, I'm just going to briefly speak to this. This is a new case that was filed against the county just, I believe, last month. This is, I know you guys are aware of the Coral Hammock vacation rental litigation. These were owners of attached units in the Coral Hammock development. There were code compliance cases that were brought against them because they were conducting vacation rentals in those units, both without a permit or an exception, and also, the department asserted that this was not permitted in the MU district because that district only expressly allows a vacation rental use of detached units. And then we also have this blanket provision in the code that says, if a use is not expressly allowed in a land use district, then, it doesn't say prohibited, but it says that, it's only authorized if it's expressly allowed. The appellate court reversed the findings of violations by the special magistrate, which is an unfortunate ruling. These owners have now brought takings litigation against the county, saying that their inability to conduct vacation rentals during the period of time that the code compliance proceedings and the appeals were proceeding, that's a taking. Well, I think this case is a great opportunity to apply, hopefully, some of the knowledge that we learned. The first is, well, okay, if you couldn't do vacation rentals, could you do anything else with the unit? Well, yeah, you could have lived in the unit. You could have rented it out long term. This is not a taking. In fact, our office deems it, frivolous litigation and subject to a potential sanction under 57105. This is another tool that's available to the county to be back to these types of frivolous claims, and that allows for the awarding of attorney's fees to the prevailing party if the other side knew or should have known that any claim that they were asserting was not supported by the application of facts or case law at the time. I'm going to wrap up with this one case because this is very important. I know that you probably have heard about this case from the City of Marathon. This is the Shands versus City of Marathon case where in May of last year, a panel at the 3rd District reversed an order that denied the Shands motion for summary judgment and remanded with instructions for the trial court to find that a taking had occurred. In June of 2023, a motion for rehearing, and we were asked by the City of Marathon to support that motion with the filing of an amicus brief, which we were absolutely happy to do. We filed one, and I know that they've cited this case, as this, hey, we're in trouble here. This decision is not final. This is still. I will say that it is a form of takings liability. Well, it actually just recognizes, a whole new category of taking that wasn't in my presentation because no other court has ever acknowledged it. It's a per se as applied regulatory taking. The problem with this type of taking is that it would essentially allow an owner to revive a per se or categorical claim that became extinguished 4 years after the adoption of the regulation by just making an application to do something that you can't do, right? So it will lead to the revival of time, claims that are now time barred. It also allows as applied claims to be cast as, quote, per se ones to escape evaluation of, those Penn Central factors I spoke to, like economic impact, reasonable investment backed expectations, et cetera. And finally, it holds that TDR value is not to be considered by a court in determining whether a regulatory taking occurred. This is even if the TDR, infuses the property with market value. And again, another thing that it does that is concerning is it shifts the focus of takings liability inquiries from fair market value to whether the property can actually be used for cultivation and development. The court actually, used the word cultivation. I mean, they admittedly relied on a very traditional notion of property ownership and suggested that any time that a regulation requires property be left in its natural state, that's a taking. That's regressive. It's concerning. It should be concerning for any local government in the state of Florida. But it's concerning to us. However, we've been pounding the pavement. We have the Florida Association of County Attorneys and a bunch of other players, including clinical programs at the University of Florida, committed to amicus participation in support of the city, if and when this case goes up to the Florida Supreme Court. And
Just a quick question. Yeah. That's its next stop. Since the decision came out of the third DCA, that would be its
it would
logical stop.
Yeah, so we go up to the Florida Supreme Court. Again, we're still waiting for a decision on the city's motion for rehearing, which suggests that based on the filings about how kind of crazy this decision was, that they may be having a hard time reconciling the decision with all the case law that we pointed out. What's very interesting is, and you don't see this happening often, is that Key Haven case that I talked about, that the state is still battling with the owner that wants to fill partially submerged lots in Monroe County. The owner filed a motion for summary judgment in that case, and the Second Judicial Circuit Court that denied that motion wrote an opinion that was pretty. So it is. I just flag it because I think at this juncture, it's enough to be aware of it, not to base decisions on it. Okay. And if you have any other questions about this case, anytime, I'm happy to answer them. I become very, it's the discussion, among land use, takings practitioners at present. I mean, I've been talking about this with, I'm on the Executive Council of Environmental Land Use Law section of the Florida Bar. It's a hot topic. It's, we've gone to a mid-year conference for the Florida Association of County Attorneys. I actually presented, on this case with, Steve Williams, who is the City of Marathon attorney. So let me wrap this up. The conclusion, it is that, takings liability remains a manageable risk, provided that there is a meaningful opportunity for additional development through a continuation of the ROGO process. And manage, slower growth is okay. This really goes to, like the rate at which, allocations, could be issued. Let's just say that, hypothetically, we got another, 2,000 allocations from the state. That doesn't mean, that we need to, immediately award those allocations. The constitutionality of ROGO was determined in the Burnham versus Monroe County decision, and that court said that ROGO was constitutionally valid. It served a number of valid public purposes in addition to the hurricane evacuation concern, right? I mean, ROGO it distributes the allocations that the state issues based on evacuation, but how those allocations are distributed turns on a number of factors that are equally valid. Windstorm protection, growth management. The court also, in that decision, also said, energy efficiency, habitat protection, water conservation. So, the rate at which any allocations are issued, it's okay if it's not today. It's over time to speak to these other issues. Also, I think a conclusion that can be derived from my presentation is that the beneficial use determination process is very successful in weeding out and resolving claims. And when I say weeding out, I do not mean putting a barrier between the property owner and the Corps. I mean, weeding out unreasonable, baseless claims. And, finally, our office's recommendation would be that the county, continue its, attempts to retire development rights through land acquisition in partnership with the land authority. So with that, I know it was a lot of information to digest. Not very sexy stuff, but thank you for staying awake. And if you have any questions, please let me know.
Yeah, you can just drop the mic on this slide. So well done. All right, commissioners. Commissioner Rice, you have a question?
Derek, thank you so much.
Don't go anywhere.
It wasn't much new because I've lived it for the
Yes.
past 17 years. But I'll tell you the unexpected result of your presentation for me, and I think perhaps Commissioner Nugent may feel the same way because he lived through those same years, was bringing up the names and faces of the people that we tussled with for many years. Lloyd Good, may God bless him, and several others that I'll never forget, tell you truthfully.
Forgot to mention Sal Gutierrez.
But that is, Sal, my God, yes. Sal and I finally reached a truce. But in any case, I've never heard a more concise, precise presentation of this topic. So thank you so much.
Appreciate that. Thank you.
I think it's very helpful.
I'm curious, how many people are on Zoom watching this?
We have approximately 61 attendees.
Good. I hope
That's
they're not
fantastic.
all our employees and maybe some people in the community as well. And I want to say thank you to everyone who is here in person, because this is a lot of information to digest. This is the first of many, many meetings we are going to be conducting, but I greatly appreciate everyone who's here today.
We can all take the bar exam on taking cases now. Yes. All right.
Thank you.
Good. Good. Yeah. Thank you so much. That was incredibly comprehensive. While we switch over to Emily, you want to take a 5-minute break? So we'll come back. Well, let's take 7 minutes. So 11:15.
I gotta start, sorry.
All right, everybody. We've got a lot of work to get through here. Up next is Emily with the much anticipated numbers, something we've all been craving.
That's item B2 on page 2 of your agenda, presentation by Emily Schemper, Senior Director of Planning and Environmental Resources, on current status of ROGO permit allocation system, analysis of privately owned vacant land and unincorporated Monroe County, and Christine Hurley, Executive Director, Monroe County Land Authority, overview on status of land acquisition programs.
Okay. All right, Emily, you're up.
Well, before I give you the number, I'm going to go through a few slides. Anyone who's watching, staff, I'll do very quick overview, background information about ROGO. So as Derek actually mentioned in his presentation, the Florida legislature designated the Florida Keys as an area of critical state concern back in 1979. Then in 1992 is when our rate of growth ordinance was adopted. So that's when we began this, and again, as Derek called out, the rate of growth. That's a key word, rate. Our previous hurricane modeling task, which gave us our most recent set of allocations, was completed in 2012. That was based on the 2010 census. And based on the evacuation clearance time with that census data, 10 years worth of building permits put the Florida Keys at a 24-hour evacuation clearance. So again, ROGO was adopted for safety of residents in the event of a hurricane and also to protect the significant natural resources of the county. But the hurricane evacuation modeling is what drove the numbers. So this was actually the first time that they had modeled out up to the 24-hour evacuation limit and indicated some sort of build out of the Florida Keys. The total number of permits for that 10-year period was 3,550 for the whole county, including Key West. 1,970 of those were assigned to Monroe County. So this is our table of current allocations and the distribution schedule. That little red arrow was originally the end date of the 10-year period. But in 2020, the county, thinking forward to, okay, what is the next round of modeling going to show? Will we get any additional units? What's the timeline going to look like? We decided to extend our remaining 3 years of ROGO. We cut the rate of distribution in half and extended an extra 3 years to give extra time for land acquisition to try to get some of those vacant parcels off the books, private owned vacant parcels, but also just to logistically allow for time to amend our comprehensive plan if the evacuation model did allow more units. You don't just get them and start handing them out. You have to adopt your procedures. You have to adopt your acceptance of the units, et cetera, into the code and comp plan, which can take almost a year. So we pushed them out a bit. We decreased our distribution rate. And at this point, we are in the, well, how do I say that? The third to last year. So we're in the middle of our year that is the first of those extra 3 years. So we give out approximately 62 per year. Those are divided between upper keys, 30 per year, lower keys, 28 per year, and Big Pine and No Name keys get 4 per year. We give them out quarterly. If you add up the totals of what is remaining that we haven't given out yet for those quarters, in the upper keys, we have 74 market rates remaining through July of 2026. Lower keys, 70 remaining through July of 2026, and Big Pine and No Name key, 10 remaining through July of 2026. Those are the market rate allocations that are given out each quarter through the Planning Commission. We do also have an administrative relief pool with 144 market rate units in it. That's an approximate number because if a ROGO permit expires, for example, someone receives a ROGO allocation, they pick up their permit, but then they never build the house and the permit expires, that allocation actually goes back into our administrative relief pool. So that number, we don't necessarily know all of the expired permits. Our previous computer system does not automatically expire it and send us a notification. So they come up from time to time and get added back into the pool. We do also have the 300 early evacuation units that were given by the state after Hurricane Irma. Those are adopted by the unincorporated county for potential use as administrative relief if they are exchanged. Then affordable units would go into administrative relief. So if you add all of those up, it's about 154 market rates through the normal process, but a grand total of just under 600 market rate units I should not label that market rate. It's 298 market rate, and then the 300 early evac, that's affordable. So I'm sorry, 298 market rate and 300 affordable. Very frequently get asked how many permits are waiting on the list. What I put on the screen here is for everyone's benefit. If you go on our website, you can actually pull up the most recent quarter and you can see who got awarded and how many were waiting on the list. The table looks like this. So this is just an example. This was after the last quarter, the lower keys. The top 7 that are sort of shaded in blue, those are the ones that got given out that quarter. Those were given out that quarter. And then the rest are the remaining inline permits. After the last quarter, we had 93 remaining in the queue in the lower keys, 122 in the upper keys, 22 on Big Pine no name key, grand total of 230. So like I said, we do have about 298 market rate allocations between our normal awards and our administrative relief. They are divided up differently between upper, lower, and Big Pine, so I did not do that split out specifically for this slide, but the grand total were somewhat balanced at this point. ROGO, of course, is a competitive point system. The main point category is based on the tier, which is based on environmental factors of the site to be built on. We try to steer growth towards the least environmentally sensitive land within the county, but there are other ways to get points as well. And when we're talking about this big ROGO topic and, will we be getting any more ROGO permits from the state? What do we do with them? What would be our preference for getting more, getting fewer, et cetera? The most important point categories for extra points are these land dedication points, lot aggregation points, and also there is an option to donate money to the land acquisition fund for up to 2 points. Those point categories all assist in retiring development rights throughout the county. So it takes units off the books in terms of vacant parcels that are not developed on yet. So I always encourage people, look into land dedication, lot aggregation, and also the payment to the land acquisition fund. That money goes to in purchasing property. You do have to get confirmation of land dedication points. This is the application form in case anyone is interested. One other thing that we did to address development rights within the county, we opened up the transfer of ROGO exemptions of market rate units. You do have to replace it with an affordable unit, but when we did that, we specified those market rate transfers have to go to single family platted lots. So you cannot transfer a group of market rate units to one site and build a huge project all at once, unless you're transferring them as affordable units. If you're going to transfer a market rate and build it as a market rate, it must go to a single family platted lot. So they're, individual development rights, again, being satisfied with a unit. We talked about the workforce housing units. Those are adopted as an exchange program that then go into the county administrative relief pool. So that's where we're at now. In 2023, Florida Department of Commerce, formerly DEO, formerly DCA, they did run the updated hurricane evacuation modeling based on 2020 census. And in November, gave some presentations down here in the Keys, and they presented this clearance time summary slide as part of their presentation. So this was a number of scenarios that they put forward. It was not a recommendation, but different scenarios that they ran. And it showed not only different scenarios of the number of allocations that could be forthcoming, but what those would do to the hurricane evacuation time, and also different scenarios of how the modeling was done. So the first large column included Key West in the modeling. The second large column did not include Key West. Within each of those larger columns, they also then had options where the mobile homes, which are permanent residents, but are less wind resistant structures. So the first column, mobile homes were included in phase 2, which is when the rest of the permanent residents are called for evacuation. So that's the later phase, closer to the storm. But the second column, the mobile homes were included in phase 1, which is actually the normal procedure per emergency management when they call an evacuation. The mobile homes are requested to evacuate earlier because it's an increased safety risk for them. This year's legislative session, legislation was passed to fix the statute so that Key West would be included in the hurricane modeling, because obviously Key West residents evacuate, so they are part of that timing. And also to specify, clarify that the mobile homes evacuate in phase 1. There's been a little confusion over the wording of that. It does say for the purposes of the evacuation modeling, the mobile homes are not considered permanent residents. That was the way of getting mobile homes into phase 1. Obviously, there are permanent residents who live in mobile homes. Evacuation of mobile homes is in the earlier phase. The clearance times in this column, then, you'll see they're divided for each scenario. They're divided between phase 1 and phase 2. Phase 2, so that's the later phase. This is the phase where in statute it says 4-hour clearance time. So you'll see this top scenario was just the baseline, you know, with no more allocations, we're at 24 hours. The only scenario that still meets the 24 hours in phase 2 is scenario 4, which is about 220 overall additional allocations for the entire Keys. All of the other scenarios would require a change to that evacuation requirement. So that's just something to keep in mind as we move forward with additional meetings and discussions about the number of units. I think what jumped out most during these meetings to everyone was this number I have circled on the bottom. I'm not going to point to it because I'll be pointing right at the mayor's face with this laser. No, you're fine. So 7,954 units. Everyone's talking about 8,000 additional units. Where did that come from? Where did that come from? That was based on the number of privately owned vacant parcels within the Florida Keys. So all the different municipalities, we all reported to Commerce how many vacant parcels we had. So you can see this table from their report. Unincorporated Monroe County had reported 6,086 vacant privately owned parcels within the county. The other jurisdictions each reported their own as well. What I've been working on for the last couple of months is taking the county's number, 6,086, and refining it, because some of those parcels are already restricted by protected habitat or existing zoning density standards. So I removed all the protected habitat, submerged land, mangroves, protected wetlands, and then with those remaining parcels applied the actual density standards. So how many acres do you need to build a house? If the parcel didn't have that acreage, I took it out. If it was required to be a platted lot and it was not a platted lot for its zoning, I took it out, for example. So this is the refined number that I have at this point. The total, rather than 6,086 for unincorporated Monroe County, is 2,220. It is approximate. I probably missed some. I did go as much line by line as I could, but it's a lot of records. I removed Ocean Reef vacant parcels because they are not part of this ROGO system. So for this discussion, it was not relevant. So unincorporated Monroe County, 2,220. I'm working on getting numbers from the other jurisdictions. Marathon is telling me that their revised number, 556, is a very similar analysis to ours. They took out habitat and applied the zoning requirements. Isla Mirada also, as of yesterday, telling me that 221, I think I saw Jennifer here, thank you. 221, same thing, they took out submerged land, they applied the zoning. I'm gonna follow up with Jennifer to see, are there any additional, wetland requirements or something, but I am trying to get this info. Key Colony Beach, they do not participate in ROGO, And what I'm hearing is that they're not interested in now joining ROGO, so I'm not considering that. Key West, trying to find out where those 84 vacant parcels are and what the deal is with those. But that was their first reported number, 84. And then Layton, they have 10. Mimi Young's telling me she thinks there's one that's not buildable, but she's got to confirm that for me. So trying to narrow down this number or overall total.
And my understanding of Key West is they've long ago assigned allocations to those lots, so they would not have a taking situation. So I would expect that number to come back as, if the question is how many don't have allocations assigned to, waiting for them, the number should come back as 0.
Theirs would be satisfied already. So, and again, this is to specifically think about that number. I am not necessarily suggesting or proposing that that then becomes the preferred number for new ROGO allocations. But I do know that looking at the clearance time summary table, a lot of people have been focused on that scenario 5, 1 unit for every vacant parcel. So at the very least, maybe we put a different number in that scenario 5, have Commerce run it again. If that were the path that was followed for a preferred number, they do also have to think ahead then. Okay, let's say we're proposing 2,500 extra units. Are those going to be assigned to the vacant lots? Because if the rationale for taking that number is that's the number of vacant buildable parcels, you need to make sure you're actually satisfying all of those parcels. So we just have to think through the steps beyond the number as well, because it could change the number.
Emily, when you were looking at those lots on one hand and allocations on the other hand, by the way, that must have been a miserable job and a long one. Thank you for doing that. Did you account for the issue where we have larger parcels of property that could conceivably support multiple family developments?
So I only considered 1 unit per parcel because when you go to the takings law, that's what you need to think about, 1 per parcel.
Okay,
if you're trying to consider the overall development potential of the entire county, that's a very different number.
Okay, that of course accounts for ROGOs. It, I think, would effectively kill our affordable housing because most people are aware today that it's financially impossible to build a single family development or property that can be rented affordably. So somehow in this whole process, we're going to have to mix those two issues.
Yes. So again, if someone's logic is, hey, we have 2,220 vacant privately owned parcels that can potentially support at least 1 dwelling unit, we should get a unit for each of them. If that's the logic for the number, it's not necessarily logical to assign each of those units. You can think of other strategies to do that. You can require a retirement of one of those rights to move them onto a multifamily site, or, I mean, we'll have to think of creative strategies for that, which is also not easy in terms of affordability because you don't have the extra money for that.
And one strategy can be the strategy used 20 some odd years ago, which is let's get it beyond our lifetime.
Or lifetime
Sorry.
for mine.
That's a varying number.
Well, who knows?
Yeah.
But that's a little bit of a humorous approach if you like that kind of humor. Some people don't. But that does help get it a little firmly in grasp, I think.
Yes, well, and what you said, I mean, your joke is actually important because, as Derek mentioned, it's the rate, the slowed down rate is very, very important. It's okay to slow it down. It's okay not to just take everything at once and put it out there. I mean, you have to account for concurrency of utilities and facilities as well, obviously, but in terms of the absolute number, it's okay to slow it down.
Yes.
Thank you. So with the 237 ROGO units left that we have, that your number is, or is that how many are in the
See,
core?
that's how many in the queue. If you go back 2 slides,
Yes, I was looking for that.
yeah, to go back 2 slides and you'll see the remainder. And remember, your printout does not include the 300.
Yeah, so, okay, so we got 298, and then
Yes.
the scenario of 4 with 11 a year for 20 years would put actually a ROGO for every lot that you've identified in Monroe County.
Well, so scenario 4, sorry for the fast movement here. Scenario 4 contemplated 11 allocations per year. And there was an option for that to be over 20 years of growth, which multiplies out to 220 allocations. Barbara Powell, who worked on the modeling and actually now works for my department, she said that 220 was actually the maximum before you would breach the 24-hour limit. So that would accommodate what we still have left in the queue, but we do also have a pool of allocations still available now that will already accommodate what we have in our queue. But that's not necessarily how it works. So if you dip into our administrative relief pool, those are not necessarily, we have nothing in our code or comp plan or any policy direction that says we'll assign administrative relief allocations to every single permit that's sitting in the list right now. I think it's too soon to know what's happening with those. But as a general balance, the county, at least, we do have about an equivalent number of market rates to what we have on the list. But again, it's another factor for decision making.
I have a question on that. That 220, though, also includes the municipalities, not just Monroe. So if this is how many we have in our queue, that's not including how many Marathon has in their queue.
Correct. That 220, at least in this table, they had distributed the 11 per year, 5 for Monroe County, 2 for Marathon, 2 for Islamorada, and 2 affordables for Key West. Again, that's not set in stone. These were scenarios they ran, trying to put things in front of us to consider, I think.
Thank you. Emily, I'm sorry. I have a somewhat unrelated question, but it's related kind of, and I've got the question. So could I ask it?
Of course.
And I know it's a snapshot in time, but how many permits do we have in administrative relief right now?
That have applied for administrative relief?
No. How many permits do we have in the bank?
About 144, and then potentially 300 affordables if anyone exchanges. Let me put it this way. If there was an affordable housing development out there right now, an existing one, if they were willing to say, sure, we will implement early evacuation on these units and exchange their regular affordable ROGOs for those early evacuations, whatever they are willing to exchange, I cannot tell you what their motivation might be, but if someone is willing to exchange on their existing units, we could put that number in our administrative relief bank. So those 300 right now are tied up waiting for an exchange. If someone out there is willing to exchange their units for the early evac, then we could put some administrative relief, some affordable allocations in our administrative relief pool and get closer to that 598 number.
Could I ask for a little?
Did that answer your question?
What? No.
I got off on.
No, it doesn't. It kind of does, and it confuses me. What do you have to exchange to get one of those 300?
So an existing affordable housing development that we previously gave affordable housing ROGO allocations too, that are not tied to early evacuation, because our,
Think the quarry, for an example.
Yeah,
sure, we'll pick on the quarry.
okay.
So I think the quarry has 280, no, that's Rutgers K. Let's say that they've got 200 units.
Doesn't matter.
So the quarry, if they have 200 affordable ROGO allocations that we already gave them.
Yeah.
Just normal affordable allocations. We have 300 early evacs sitting over here in the bank. If they were willing to say, we'll implement early evacuation at the quarry. They have to do a
already have,
management
haven't
agreement, not that I know of.
Oh, really?
If they're willing to implement that early evacuation requirement, we could take 200 of those early evacuation allocations, give them to the quarry, take the 200 normal phase 2 evacuation allocations back and put them in administrative relief.
As affordable or as a market?
It would be affordable, so it changes how they can be used in terms of liability, but they are still important and useful, and that was the whole theory behind how they were accepted. That was the whole discussion that the board had about, should we take them, should we not? The board talked about really wanting to only take those 300 early evac if they could be used for administrative relief in the future, and that was not an option to put them directly in administrative relief.
And so forward to a future property owner who owns this gorgeous piece of property, very expensive, and he doesn't get an allocation. One of the claims that Derek talked about was a Burt Harris claim. And one of the ways that Burt Harris allows you to do is to bend the regulation just enough so it's not an inordinate burden. So that affordable allocation, the court, if it approves the settlement agreement, they could bend the affordability part of it, lift the affordability part.
So we wouldn't require them to continue building a home as an affordable house. In that category, we could bend it and say, now you can build your regular
right
home.
It would solve that claim.
No wonder nobody really understands this. Wow.
We were on the board when we approved this.
Well, I know I helped get us there, but where is there, you know?
Madam Mayor, can I ask a question?
Yeah, please.
So basically, all the affordable units that were deemed affordable unit ROGOs in the past, they could all be market rate, but we designated in previous commission, certain percentage had to be affordable. So, and you're saying they could be changed back?
Well, it was a state requirement. I believe that at least 20% had to be affordable.
Did we
The
keep it at the
county,
minimum?
I believe, did 30%.
Okay.
It was 710 out of that 1,970 that we got at the last. That's what was reserved immediately for an affordable housing pool. So again, another layer going forward. If we settle on a number, what are we going to do with them? It's another layer of.
So you're saying that the ROGOs, the 300 ROGOs can only be used for affordable, but if they traded them back for those affordable for some of the 300 that can only be used for the early evacuation 300, in Taken's cases, we could use some of those affordable ROGOs as market rate.
Yes, essentially.
Essentially, okay.
In the context of one of those cases.
Right.
Not just a switch and then we give them out.
Right. It would be to settle a claim as opposed to an award through the ROGO competition.
Yes, because that would have to be under tight control there.
Right.
For sure. But a possibility to save some high takings cases of certain properties. Okay, thank you.
So going through the BUD process.
Yeah, they'd go through the BUD process, and again, this would be to solve litigation, so they'd have to have a mature claim, which takes them through the BUD process.
Go ahead, Emily.
Do you want me to go forward? I think I have one more slide, two more slides, and then Christine So the last thing I wanted to go over was just a summary of our, you know about most of these already, our current efforts and initiatives to retire development rights, because you think about that 2,220 number now, we can still keep trying to bring that down. Christine's going to talk about, what the Land Authority's been doing and is still pursuing. So we have all our ROGO points categories. They're all trying to achieve that goal of bringing down development rights. So these ones: land dedication, lot aggregation, payment into the land acquisition fund. I didn't put it on the list here, but then that policy about transfer of ROGO exemptions that I mentioned, having to go to the single family lots, that's also, again, trying to take the allocations we have and spread them to as many vacant parcels as possible. We extended ROGO out the extra 3 years. That's the extra time for land dedication, aggregation, and points payment, more land acquisition, and other retirement of development rights. And then Christine will talk about Land Authority. We do have a few things that we're still working on. You may recall we had the huge table of ROGO ideas. I think the last time we brought it to you was almost 2 years ago now, probably. And there it was revisiting this table of ROGO ideas, and should staff pursue certain ideas that will help reduce development rights throughout the county. We are working on a contiguous land merger ordinance based on direction from that time. So contiguous properties that otherwise would have more than one development right, if they're owned by contiguous owners and meet certain criteria, could be merged to automatically become one development right. Abandonment of unimproved rights of way in undeveloped subdivisions. We have some of these subdivisions way out in the native area. They're platted, but nothing's ever been improved. There's no roadway improved. We can abandon those rights of way, and that changes the expectations for development. And then there is some potential for establishment of urban service districts. It's a little odd down here because we're so constrained anyways, and so focused against the highway already. But if you set up an actual urban service district, that's a boundary beyond which you clearly state that you're not extending public services. So, out into those native area districts, we don't have the services out there already, but if we set the boundary, it just helps with the liability later. Any questions by portion? Any more questions? Christine has a few slides about land acquisition, and then Kimberly will talk to you about process after that.
Wow, Emily's a lot taller than I am.
There's a button on the side that you can bring it down, Christine, if you want.
I'll live with it. Okay, good morning, and thanks for allowing me to present with Emily today. Basically, what Emily did was set the framework up for why the Land Authority exists in the first place, which is to purchase as much land as possible through many different programs that have evolved over the years. And what I think is important for this commission to recognize, because some of you are not here, in 2012, when the hurricane evacuation model was completed, all the county staff knew that there would be a big need for way more money than the Land Authority was collecting annually from the bed tax. And so budget money from infrastructure sales tax into what we all commonly call the 316 fund. And at that same time, we developed different programs than the Land Authority had traditionally been using. So back then, it was all about conservation land. It was all about, how much habitat you can buy up. And it still is, as that's a big part of our mission. But the board created the density reduction program, where it broadened what the Land Authority focus was, which is to acquire all developable land. In other words, how Emily just said there's the 2,220, that's kind of the magic number of lots now that would be eligible for the density reduction program, because those lots at least have one TDR. And that TDR is what gives you the ability to ask for a building permit. So the board, over the few years following, budgeted about $7.5 million to be used in the density reduction program. And since then, another $1 million was added from the fund that Emily talked about, where people will buy points into a land acquisition fund. So since around 2016, when we started the density reduction program, we've bought about 25 TDRs, or 25 vacant lots, for about $1.6 million. And that's important because that shows us kind of, the going rate for those developable properties, which is different than the going rate for a conservation property. The other thing is, when we buy those density reduction lots, we are then able to take away the TDR and just create a situation where the next door neighbor can buy the land, use it as part of their yard, for a pool, whatever they want to do, as long as it's not habitable space. In other words, we don't want them to create another living unit on that lot. So of those 25 that we purchased, 14 of those have been resold to the next door neighbor and are now off our books as not something we own. We raised about $547,000 in those resales. And then the most popular program of all, which we have a huge waiting list for, is what we call the less than fee program. And this is an interesting program because often a property owner will buy the lot next door. They're really not thinking about building another house there, but they want to maintain that ability, things like that. Well, we created this program where we buy the development right from them, but they keep the land. And so far we've bought 95 of those. It's been very successful. And if you look here, we have 190 people in our waiting list for that program. Based on the average amount we spend per lot in that program, we would need about $10 million to take down those 190 applicants. But
That'd be 190 units?
Retired, yes. So where are we today? And this is the important part. To buy those 95, we spent about $5 million. So we have pretty much spent down the $8 million that were originally budgeted. And I did submit last week a request through Kevin Wilson and Tina to ask if you all would budget another $2.8 million in that fund so we can continue to work on the density reduction and the less than fee purchases. So as the budget goes forward in this next season, we'll watch that and see, what gets added to that program. And then, so this is the request that I just itemized. If we are given that amount of money, we think we could do about 5 density reduction purchases and about 48 less than fee purchases, which is based on our staffing, what we think we could achieve. Obviously, even if you gave us $10 million for the full 190, we don't have the staff resources to do that many deals in a year. And then finally, just overall from the Land Authority perspective, in our normal operations for conservation purchases, that funding comes from your bed tax or a park surcharge. We right now collect about $5 million a year in revenue, and we've been spending more than that. And the reason we're able to spend more than that is the state of Florida has been an excellent partner in letting us pre-acquire the conservation land, reselling it, thereby replenishing our money so we can just do more and more. That is going really well, and I believe the budget year that we're in right now, instead of $5 million in revenue, we budgeted $14 million. So those resales make a huge difference for us in what we're able to accomplish.
Christine, you said something there that maybe needs to be pointed out. You said we resell it. We don't just resell it. We resell it to the state. They pay us. And as you said, that we use that to buy more land, but that property is still.
Gosh, yes, absolutely. Thank you for that. Yes, yeah, and once it's in the state's hands,
Forget it.
hard to rip it out. But any questions?
Commission? Good?
Thank you.
Well done, Christine. Thank you. Is it all right if we get to Kimberly? Or do we need a break? You good?
No, just,
I feel like she'll be the cherry on top of all of this information.
I did receive, they are watching this and they have their hand up in the virtual waiting room for.
Got it. And we will get to that in discussion and public comment.
That's what I told them.
I won't forget to ask for that.
All right, now
All right, Kimberly.
I'm going to have to lower it.
I think it's on the other side, isn't it? Help her out there, ladies. There should be a little toggle switch.
It's right in front.
Oh, there we go.
Okay.
Welcome, Kimberly.
Thank you so much. It's a pleasure to be here, Mayor, Commissioners. Wanted to go through, the last time I presented to you, I presented focus specifically on the public participation process, but I have been asked to quarterback the overall coordination of the entire process. And as the team has been meeting, we have discovered, and we knew it, but it's become even more clear to us how intricate and detailed this overall process is going to be. So I want to talk about that today.
Kimberly, 1 second. Madam Clerk, did you need to read the item into the record?
I can if you'd like me to. That's item B3 on page 2 of the agenda, presentation by Kimberly Matthews, Senior Director of Strategic Planning and Libraries, of the public input process for future changes of ROGO and evacuation time.
Thank you so much. Already.
Super. So process for consideration of future changes to ROGO. The purpose again of this process, so that not just the public participation, but the process is to combine county planning information with community conversation to gather input from residents, stakeholders, municipalities, and other agencies for your use in your decision making as we move into December and forward. The team that we've put together from the county involves Kevin Wilson. Just to, kind of to recap, we may have people who weren't watching the last meeting. Kevin Wilson, obviously overall oversight as acting county administrator, me, coordination of the overall process, and then also facilitation of the input from community stakeholders and municipalities. Emily and her staff for all things planning and ROGO. Kristen will be helping us with PR and social media expertise. Derek Howard with takings. Bob Schillinger, obviously all things legal, keeping us on the straight and narrow. And then Shannon Weiner also is going to step in and help us with, since we are talking about evacuation and emergency management, she'll be talking about that with us. So the process, really we're going to focus on 3 phases for the overall process. We do know that we need to have you all making a decision probably sometime in December at your meeting, and so that you can then put that on your legislative agenda moving forward. So the three-tiered process that we're going to do is an evolving process. Is going to continue to narrow our focus. We're going to start with a 30,000-foot view of, as we plan, we gather data. There's so much data that Emily and her team need to gather, and we're going to talk a little bit more about that. But also, as we start to talk with the community, we're going to start from a broad perspective of what are your thoughts, what are your considerations, asking the municipalities the same question. Then in phase 2, we're going to narrow that focus. As we gather more data, we can start to hone in on some of the specific talking points that we want to focus on. And then in that home stretch at the end in October, November, really getting down to the meat of, okay, so we've been talking about this, we've talked about specifics, we've narrowed our focus, where are we at, where are we landing? On the back end, we also, that's kind of the public process, but we also have the how are we getting to that? We've got the team collaboration, and that's going to be ongoing for all of these 9 months. And that is the team that you just saw, internal planning, analysis, and making adjustments to the process as we move forward. So that's an important piece of this. As I outline it today, this might not be the final version of what it looks like when we get down to the end. It will be flexible and evolving. Obviously, the public engagement portion, which involves the outreach to and direct feedback from the community and our stakeholders, that'll be done online with workshops and presentations. And then the conversation and collaboration with our municipalities and with other government agencies. All right, so the evolving process, again, as I've sort of described, that first phase is the broad look at many considerations, because we want to take just a real open-minded approach of what is everyone thinking? Where is everyone at this point? This is the opportunity for the planning department to continue their data collection. That's going to be the next slide. It's going to be detailed on that. Using an online tool for broad public feedback, kind of the what are you thinking? What are your biggest concerns? What are your biggest hopes? You know, what would you like to see from this decision, this process? Educational information for knowledge calibration. It's a little bit of what you saw today so far in today's meeting, but also creating some tools for the public. I was in a meeting a presentation that Bob did to the Rotary in Key West, and it was interesting. Afterwards, we both received feedback from someone that they were like, you know, I've lived here forever and I know all about ROGO, but I was surprised. I was sitting at a table with some other folks who've also lived here for 30, 40 years, and they were like, I didn't know any of this. So even when we think we know, maybe there's things that we can learn. And so we want to do some educational information on takings. A one sheet on takings, a one sheet on ROGO, and then also a one sheet maybe on evacuation and you know, that kind of issue, those kind of issues, so that we can just all be on the same page with language, etc. Meetings with our stakeholders and initial discussions with the municipalities, and then of course the ongoing workshops with all of you. In phase 2, we'll move to that focused feedback. This will be focused with adjustments made with data and the feedback that we're gathering. So as we go, as I've mentioned, focusing and honing our questions and what we're talking with the public about. This will be where we go to the outreach meetings with the community and, again, ongoing collaboration with the municipalities. And then in the home stretch, we want to talk about final thoughts, the series of final public town hall meetings. So, you know, we're going to go out to the community. We're going to go to our rotaries and our chambers and all of those, you know, the HOAs and all of the normal usual suspects, but then we also want to have some just open public conversation that anybody within the community can come to and participate in that, not necessarily a BOCC meeting, but in a formal town hall. And then also accepting final feedback in the November timeframe and the recommendations from the municipalities, finding out where they land so that you can factor that into your December decision. All right, so as I mentioned, planning has some next steps that they need to do. They're going to be looking at continued updating similar analysis that Emily gave to you about private vacant land, and we need to get that from the municipalities so that we can add that data into her information. More information on evacuation timeframes. Then we also need to, as we're having this conversation, one of the first things that a lot of people ask is, okay, so if we add ROGOs, if we add more development, what does that do to our infrastructure? So planning department is going to be looking at that data and gathering that in the best way that they can so that we can factor that in as we narrow our focus. The economics of it, the monetary costs, social costs, environmental costs, et cetera. The different types of allocations, all the different ways that we could coordinate this, the different options of how we can roll this out. And then speaking of rolling it out, the rate at which we can roll it out. So they're going to be gathering all of their options, gathering all of that data as we progress over the next few months. And then we can factor that into our questions and our presentations to the public. All right, and then the timeline. So March through May, and this will be evolving because, for example, the last time you saw this slide, it said March and April, but what we've learned is that really we're not ready to go out and I'm not ready to go out and do those presentations to the public because we really don't have good questions to ask the Rotaries and the chambers and the HOAs. We need to have that time frame where we gather our data so that we can ask the meaningful questions because they don't want to see me 3 times over the next 9 months. So We want to save that for when we're ready. So instead, for now, what we're doing is team coordination, development of and deployment of the educational information that I mentioned, also that online survey tool, because we want to, again, open it up with a broad, open-ended, let the public tell us what they're thinking, because then we can factor that in as we narrow our focus. The planning team is going to work to establish criteria for the most important feedback. We need to know what you all need to know to make your decision. So we'll be having a lot of conversations with you as well. Book and promote the community meetings starting in June. The commission workshops, so here we are in March. You've received some information from Emily, Derek, and Christine. And then in future meetings, we're going to rather follow the same template, which is updating you on the process, giving you any feedback that we've already received that we've been able to analyze, and then also, additional information from the team as far as education, et cetera. And then also we want to begin the discussions with the municipalities. That really can't happen too soon. So, and then also stakeholder meetings. In June through September, again, ongoing coordination, that online survey tool. At that point, we'll probably be able to tweak that, narrow the focus of that to match the questions that we're asking in those presentations and meetings. Then also continue to have the workshops with the BOCC, the coordination with the municipalities, the stakeholder meetings, and then begin the presentations where we go to the outreach to the community with focused questions and gather the data. And then October through November, that's bringing it into the home stretch, a final series of those public town hall meetings that I mentioned throughout the county, here at the government centers, that any member of the public who wants to weigh in can do that. The final data collation and report for all of you, your commissioner workshops, coordination with the I can't say that word today. I don't know what my problem is. Coordination with the municipalities for their final input. So we'd really like for them to shoot for in November. Their meetings in November, we'd really like to hear what their final decision is or their recommendations and where they're landing so that we can bring those to you for your December meeting and your December decision. And then December, final workshop and decision with you. The process will evolve with feedback, analysis, and additional data. It will educate the community and stakeholders on all aspects of the issue, work in collaboration with the municipalities and other government agencies, allow for input from the members of the community, and provide data-driven analysis for all of you so that you can make your decision in December. Does anybody have any questions for me?
Commission, questions? All right, thanks for that outline. I know it's a map for our adventure. Okay, Madam Clerk, shall we go ahead and start public input? Should we go ahead and rock and roll? Okay, your speaker.
Okay, your first public speaker is Sue Miller, and she'll be followed by Van Cadenhead.
Madam Mayor, typically we have an announcement somewhere along the way that, since the blue cards don't just keep rolling in.
Oh, yeah, so now is the time to fill out your blue card if you want to speak.
And virtually on Zoom, raise your hand.
Yep. Captain Ed, it's over there, out by the sheriff deputy. All right, Ms. Miller, you're recognized.
Sue Miller, Isla Morada. I want to thank you very much. This has been such an informative meeting. I really have learned a lot, and I thank you for all of the efforts of all of the presenters. And I think we've all learned a lot and learned that you probably need to go to law school before you sit in your seats.
All right.
And I hope that you continue to allow public participation. I know as a sometimes frustrated resident that I feel that we ignore the needs of those property owners who have lived here and have expectations about the infrastructure that we need and the protection of the environment that is the reason we're here. And we look at the development, the future development, as if those property owners have greater rights than those of us who already are here. And I enjoy hearing all of the takings issues, and I hope that the property owners that are here have a loud voice in this process, and I thank you, because it looks like they will. Thank you.
Thank you. All right, next speaker.
Okay, your next public speaker is Van Cadenhead, and he'll be followed by Dottie Moses.
Good afternoon, ladies and gentlemen. I'm Van Cadenhead. I've been a resident in the Keys since 1956, when my parents bought Mandalay Marina right down the street here. And it was a whole different world then. But as your attorney Howard said, we're living in a fantasy world now, because the discussion of our evacuation times is tempered by what's happening at the way you're allowing building to continue. And I use as an example the CEMEX project is a block of the traffic right there, a roadblock at Burton Drive in Tavernier. And once that gets filled in full operation, and we have a hurricane that jumps up in the Bahamas from a category 3 or 4, we're going to have people wanting to get out of Key West from Mallory Square all the way to the Georgia line. And I think that to allow something like that to happen is within your purview to stop. And I do not understand how you could possibly have, in good conscience, passed the CEMEX project with 100 people here in the room to see to it, and 35 people speaking against it, and you still eliminated their comments and their wishes and their insights, because they live on the spot where it's going to happen, and still go ahead and okay that kind of a project. That does not...
Mr. Cadenhead, please stick to the ROGO workshop.
Okay, well,
it's a different topic.
It's all tied together, Madam Mayor, because the ROGO workshop to assimilate 8,000 new permits is just, that's fantasy world. We don't have a place for 8,000 new permits. And it may cover you as far as administrative relief. I've listened to a lot of different arguments today. I sat on the LPA of Islamorada for over 3 years, and I sat in on the land acquisition board and worked with Mrs. Hurley to acquire land. And there's a whole lot of good things being done to take down the number of buildable lots and then decrease the density of Monroe County. But the fact of the business is we've already been overbuilt for years. And you can call it any way you want to call it, but you can tell it in the traffic, you can tell it in the strain of the people, and I'm seeing a red light, so I'm out of here. But please consider that we need your help to restrict growth here and not permit any more unbridled growth like we've seen.
Thank you, sir.
Thank you very
Next
much.
Speaker.
Okay, your next speaker is Dottie Moses, representing Last Stand and Island of Key Largo Federation of Homeowners Associations, and she'll be followed by Andy Tobin.
Morning, Mayor, Commissioners. I'm Dottie Moses, and I'm here today to speak on behalf of Last Stand and the Island of Key Largo Federation of Homeowner Associations.
Dottie, can you move your mic down just a tiny bit? Okay. There you go.
Thank you for the opportunity to speak on this important issue. The future of the Keys is at stake. What will we look like 10, 20, 30 years from now? Our comprehensive plan is very clear in its purpose and goal to protect the Florida Keys for future generations. It recognizes and emphasizes our limited carrying capacity, our fragile environment, and our limits of a safe to a safe evacuation. The goals and policies support slow, limited growth, and for the most part, we have kept to that agenda. There's now a fear that we may be moving away from our slow, limited growth. We hope that is not the case. We are hopeful you will decide to stay the course and continue to protect our natural and historical resources, as well as protect the investment we have made in our public facilities. We as a state and a community have faced the very real threats of overdevelopment, the loss of our natural environment, and the risk of tragedy as a result of a hurricane. We have worked together diligently through the years, holding numerous community meetings to find reasonable solutions to protect our community. Our work is not done. We still face the same threats now as we always have. The pressure to overdevelop the Keys beyond its carrying capacity is alive and well. There is evidence that we already have exceeded our carrying capacity. Our water pipeline is falling apart. Our roads are flooding with more regularity. Shallow wastewater injection wells have proven to be polluting nearshore waters, and the level of service on US 1 is failing. So let's not double down and compound an already troubling situation by requesting more unsustainable development. We knew that there would come a day when we would run out of ROGOs. So the voices out there who are advocating to take as many ROGOs as possible are not helping to find a sustainable solution. We need to take as few ROGOs as possible. Nothing has changed to justify increasing the risk of being able to safely evacuate or to justify jeopardizing the protection of our remaining natural and historic resources. Our limited growth has been data-driven and therefore legally upheld. If we suddenly ignore our very real limitations and arbitrarily increase our allocations, what will we become of our past legal arguments? We open ourselves to even more litigation? We should be exact in our use of any remaining building allocations and any additional allocations that may come from this remodeling. We should use them strategically to serve the greatest needs of our community. They should not be used to create more vacation rentals or another resort, and they should not be used for a third or fourth house. If takings cases are the concern, then let's set them aside to resolve those issues. The lack of high-end housing for people who can afford it is not a problem in the Keys. Affordable housing for working families and property rights issues are the priority, and all new development should be limited to addressing those issues. And we should new ROGO units should be tied to a work plan with specific yearly tasks, as has been done in the earlier phases of ROGO. Tasks such as completion of the water pipeline replacement, completion of wastewater projects, level of service improvements on US 1, road elevation, stormwater improvements, and other infrastructure improvements, as well as meeting our land acquisition goals. We need to find other ways to encourage affordable housing other than just increasing ROGOs. We should put more getting the Keys exempted from the limitations of regulating vacation rentals and not into increasing hurricane evacuation times. Increasing the evacuation time does not make sense. US 1 capacity has not increased. There is no data to support it. Our very first goal in our comprehensive plan states that Monroe County shall manage future growth to enhance the quality of life, ensure the safety of the county residents and visitors, and protect valuable natural resources. And this should be front and center of every decision we make. We need to think more strategically on how to solve our problems without adding to them. Every ROGO decision must be the perfect decision. We cannot continue to fragment our hardwood hammock, build homes in flood-prone areas, decrease the community's safety by increasing evacuation time, negatively impacting our water quality, increase our traffic, or add more pressure to our infrastructure. So please stay the course and continue our strict and limited growth. And our slow limited rate of growth ordinance has proven to be successful and is held up in courts, so let's continue to support it. I thank you. I just want to make one comment after hearing the discussions. Are we going to deduct the ROGOs that are being the less than fee lots and the administrative relief ROGOs and any existing unallocated logos to that 2,200? I mean, those are.
Emily, are you prepared to answer that, or do you want Dottie to get with you offline?
I think that's a.
And after Mr. Tobin is.
Okay. And after Mr. Tobin is David Helwig.
Good afternoon. For the record, Andy Tobin. Since most of the taking cases that Derek mentioned are mine, I think that at the next meeting I should be given equal time, but we can talk about that later. Historically, just to put things in perspective, we challenged the rate of growth ordinance back in 1992 when it was being debated. And one of the things that we found out, because we did a survey, is that most of the people in Key West and south of the 7 Mile Bridge are not going to evacuate. We suggested that maybe the county should be building hurricane shelters in the lower Keys and taking 20,000 people off the road and actually solving the problem. So, but ROGO is here, and we've learned to live with it. My suggestion is that you do increase the rate of growth ordinance cap. I don't think people building houses are the problem. As you know, I have challenged the 7-Eleven at Anthony's, and I also was challenging the CMEX. I think that the real problem in the Keys is now commercial development and redevelopment, and additional houses are not really the ROGO problem. I don't want to deviate from some of the other issues that you're facing, like taking litigation. And I know that the Constitution talks about just compensation, and that's sort of the amount of money is in the eye of the beholders. You've got fiscal responsibilities and raising taxes and those kind of things. Property owners have other expectations. That's not really an issue for today's discussion. More single-family homes, I don't think is going to critically interfere with the evacuation model, because lately, from what I've heard, since you can't even get back into the Keys after a hurricane, I think that there's going to be fewer people that are going to evacuate. The mobile homes are important to get those people out. New construction, I don't think is at risk, but maybe it is. And when we went through the comprehensive plan challenge in '92, one of the issues was, how are we going to resolve, if people do stay and there is a hurricane, how do we service those people? I was here in Andrew. We didn't use air conditioning. We lined up at Key Largo Fisheries for ice. And I think that if we can, set up military bases in Iran and Afghanistan and put in dockage in other areas that people will be safe here in terms of getting food and electricity. So I think ROGO is important, but I don't think it should be the be-all and end-all. So I do recommend that you increase the cap. That'll reduce the taking litigation, give people the expectation that they had when they purchased the property. Some of the other issues are really not relevant, so I won't go into those.
Thank you, Andy. After Mr. Hellwig
would be Captain Ed Davidston, representing Florida Keys Citizens Coalition.
Okay. Mr. Hellwig, you're recognized. Welcome.
Well, first of all, thank you very much for today's session. It was very informative. I don't envy you struggling with this over the next year. But anyhow, thank you for the session and the process going forward to allow for further communication and involvement. I think that's very important. I heard today things both encouraging. I won't enumerate those, but the one that stands out and probably was more eloquently stated by the woman several before me about the quality of life here and how important that plays in. So the one thing in that regard, the thing I didn't hear come out explicitly in the process is the level of service standards for the roads and transportation. And if I'm not mistaken, that flows through both the land development regulations and the comprehensive plans. So it's it's kind of the close cousin to evacuation modeling because it's all about the capabilities of the roads and a number of people on it. And in reality, the evacuation modeling has some subtleties to it. It relies primarily on census data. I hope to have further dialogue about that. I've got some experience in that regard, being responsible for evacuation modeling and protocols myself in past careers. But part of that, to relate the two, the evacuation modeling and the level of service standard, comes right down to actually at its heart the census data and how subtle and complex that is relative to who's counted. So last time I looked, based on the latest census, 32% of the properties in Monroe County were, quote, vacant. Now, in census terms, vacant includes everything that isn't owner occupied. So it's got rental units, but it also has what they call units that are owned by people who usually reside elsewhere. Second homes, and it turns out a whole lot of those end up these days being Airbnbs and VRBOs, which have a pretty high occupancy rate. In fact, the best data I've been able to find, there's over 10,000 official such units in Monroe County. And that's pretty complex to make sure that's considered properly in the evacuation. And I happen to live at the place where the road narrows down to 2 lanes right in front of Coral Isles High School. Morning or any afternoon and see what's going on there.
Got it. Thank you, Mr. Helwig.
Thank you.
All right, Captain. After Captain Ed, online.
We'll be going to online.
Okie dokie. Welcome, Captain Ed.
Speaking on behalf of the Business Coalition, as I've been doing for more than 40 years at this council. David was here, I think, then. No? Okay.
I was in the Keys, but not here.
Okay. Yeah, he's doing some good work in Marathon. I usually get 5 minutes. I appreciate it because I'm going to quote some legal stuff for you. Great legal briefings. My lawyers know your lawyers and have for years. But you need an equally serious briefing from them about all the current case law that my environmental lawyers tell me about that do clearly not require local governments to provide taxpayer-funded expansions of infrastructure to subsidize future development. That your only requirement is to maintain infrastructure that you already have. And infrastructure is the problem. A lot of these other discussions are theoretical planning. Oh, by the way, for the record, I was once upon a time chairman of the zoning board for Monroe County. Once upon a time, chairman of the Comprehensive Plan Drafting Committee, as it came out of critical concern because Bob Graham's staff, Governor Graham, champion of the Keys in all of those processes.
We're getting old when we're talking about all the former things we once were.
Yeah, well, but I've been involved in growth management ever since, as I'm sure you remember. You need that briefing because there's an implication that from development interests that you have to put up with the traffic. You have to. I had some recent experience as an elected official on the school board. The 3 schools that we authorized while I was sitting on the school board cost $36.5, 37, and 38 million taxpayer dollars. And remember, in Monroe County, as you guys know, a lot of the public doesn't, we fund 90% of our own taxes. A lot of northern middle counties get half of their budgets paid for by state taxpayers, not us. We pay our own bills. And that was on property we already owned. To build a school now, $10, $15 million for a chunk of property, if there was one, which I doubt. All those schools are full, which a lot of people don't know. They're already full. You get another couple hundred kids, what are we going to do with them? There's no feasible solution, and then what do we wind up with? Trailer campuses? It was about a year ago when they had 4 ruptures in a single week because, as Easter approaches, they were pumping max volume and max flows, 4 ruptures, and they haven't been able to pump full capacity in the year since. So far, with all that construction in the middle of the highway, they have replaced about 4.5 miles, working on another 1.5 miles. The estimated full cost, 130 miles in 15 to 20 years, $2 billion. That's their public estimate. I believe they raised 44 mil just for the, it's $10 million a mile and likely to get worse with huge dislocations to the traffic. They also got cited. They were at one point in the last year under DEP supervision, Department of Environmental Protection supervision, 2 consent orders and a warning letter. Engineering at the reverse osmosis plant was not up to specs. And as the Miami Herald expose pointed out, the $1 billion sewage treatment plant on Cudjoe Key, which they built within 2 years, leaked about 200,000 gallons of untreated sewage into wetlands and nearshore waters of the lower Keys. We have huge infrastructure problems that we're nowhere near to solving. At another presentation, this other lovely document I have here is the sworn testimony of the state's leading evacuation modeler. The model is fundamentally flawed. This is the only single county evacuation model. It's a farce. Every other county does simultaneous, but this model alone, when they updated it, and everybody in the game knows this, we're at 26.5 hours and we have been for 9 years, violating state law, issuing more permits. That's a real mess, and the evacuation model, it doesn't measure anywhere near reality.
Thank you, Captain Ed. All right, Madam Clerk, how many speakers do we have online?
Giovanni, do you have anybody online?
I believe we have the City of Marathon.
4.
Okay, let's hear the first speaker.
Okay, first speaker, we have Williams with a double S, Williams.
Good afternoon.
Oh, is that Steve? Can you state your name for the record?
Yeah, this is Steve.
Oh, hey, Steve. Okay, you're recognized.
Oh, thank you. Good afternoon, everyone. I promise I'll keep this presentation slightly shorter than Derek's. Again, you're very fortunate to have the legal counsel that you do. I mean, Derek is, I would consider within the top 5 to 10 people in the entire state of Florida on the topic. His knowledge, background, and involvement with regulatory takings is just phenomenal. He's well published on it. He's well spoken on it. And there is nothing that he had in his presentation that I wouldn't be proud of if I were the 5 of you. As a city, and the reason for I'm speaking, I believe Commissioner Lincoln raised the issue of a moratorium. Derek opined on that. And just as a city, we may have a slightly different take for slightly naturally more selfish reasons in protecting our own interest. The major issue I could see with a moratorium, I would hope that Derek and Bob could agree to this, at least in part, is that one of the primary functions, not functions, but defenses of the moratorium is the duration period. If we were to attempt to place a moratorium at this time, I really would not have a defined duration for said moratorium. I think it would be somewhat vague to say either until Tallahassee gives us the units or until the county agrees to lend them to us. For one way or the other, I could have difficulty defending that moratorium.
You just make it for a year and then renewable if the circumstances haven't changed.
Well, again, and I agree. If it would be done within a year, it would be great. But if it's not done in this year, we would have no defense to when Tallahassee would do it. It would be beyond our control. We would not control the units. And if we can't really control the length or duration of a moratorium, naturally we would put it for a year, or we do that with virtually everyone the county does or the city does. But if you don't run out until 2026, and I believe as Commissioner Rice said, is this, we could just put this beyond our lifetime, the city could be facing a potential moratorium of 3 or 4, not knowing how the politics would work out. So it does cause us some concern with the moratorium versus just the lending of units that we'd agreed to before the legislative session. And I think the city would just like to keep going down that path with the units that we agreed to before the session. So I do appreciate Derek's budget in comparison to yours. Would have a far greater impact should that decision not be overturned by the Third or the Supreme Court. And if that's its valuation for that parcel, for the two of you on the commission who are familiar with Marathon, that is the 7.9 acre island just to the west of Stirrup Key. And the valuation on that particular lone parcel does have 2 commas in it. So if we take the new number that Brian provided Amy, I think you had on your slide from Amy at 556. Naturally, that causes us some severe heartburn. So again, we're still in lockstep with the county. We want to proceed with this with the county. We appreciate Emily's great presentation, certainly Derek's as well, and Christine. We don't want to get off that boat, but I would just have probably a little more, I don't know, hesitation about the concept of a moratorium than perhaps Derek does. It doesn't mean Derek's wrong or I'm wrong. It's just from the city's perspective, our safer route to protect our citizens is to have some units available for the short term to prevent a takings case. We also have, as Derek outlined, we have a BUD process as well, and we would not use that to prevent anyone from bringing a takings case. It would certainly be part of the process. It may slow it down just to get them the administrative relief that they deserve. So I had my hand raised earlier to try to attempt to answer this right when Commissioner Lincoln and Derek were speaking, but I think that's our perspective. We apologize for not being up there in person, but as you're going to have multiple meetings, we'll certainly attend the one where you're here in Marathon. And if you do want us to come to all of them, we'll be glad to. So I can answer any questions. And as an attorney, I kept it under 5 minutes. So
Good job, Steve. All right. Thank you. Say hi to George for us. All right. Next speaker.
Madam Mayor,
Okay. Hold on 1 second. Commissioner Lincoln.
Steve and Marathon, I did not mean to cause heartburn for you all with the discussion of the moratoria. I just wanted to bring it out as an option. But to your point, we did kind of say, yes, we would lend you units, and with good faith, that's why you all backed off when we were in Tallahassee. So if that's the direction they still want to go in, I'm still backing you all in that.
Thank you. Thank you for that clarification. All right, Giovanni, next speaker.
Next speaker we have is Patricia McGrath. Please accept the prompt. Thank you.
Good afternoon. My name is Patricia. I'd like to thank the staff. I think y'all did a really good job. Commissioners, you don't have an easy job or position where you are. We need help. The citizens of the Florida Keys need help. We need relief. There's I don't think you understand what it's like to live in a place where you never know from 1 minute to the next if you're going to be able to even get to the hospital if you need to. Everyone since the 70s, when the area of critical concern came in, and the 90s, every governmental entity or council, commission, agency, you have all been complicit in allowing the extreme overdevelopment that's happened here in our area of critical concern. You've been unable to manage traffic, water quality, vacation rentals, and particularly the tourist development camps. So instead of just a moratorium, is it possible that we could declare a state of emergency in the Florida Keys? Because we're in trouble here. And a moratorium is not going to help it. We need all growth to stop now, period, until we can figure out a way out of this mess. And I don't mean just you commissioners. I mean as citizens. I mean, does it matter at all what the residents want?
Oh, thank you, Ms. Patricia. Giovanni, next speaker.
Next speaker I have is Alicia Putney. Thank you for accepting the prompt. Please press *6 to unmute your microphone. Alicia or Alicia?
Giovanni, we'll come back to her. Next speaker.
Okay, next speaker is Marlon Weeks. Marlon Weeks, please accept the prompt. Thank you.
Good morning or afternoon by this point, commissioners and mayor. Thank you all for the presentation and for the staff. I'm going to throw just a few different perspectives here because I haven't heard from any property owner that would be directly impacted at this point, and my family is one of those. I have my husband has been here, his family, since the 40s and the 50s. So we definitely have seen as a family how the Keys has evolved and grown. I've been here since the 70s. My family were general contractors and developed a lot of properties in the Upper Keys. I was also here as a teenager when there was a complete halt to construction, and a lot of the big construction outfits went bankrupt. So there's a lot of implication here to the positions that you're going to take, and I don't envy you in that part. But I just want you to hear from a property owner's perspective in real time. We've done everything, my husband and I, as we were supposed to do. We started our family, we grew our family, we saved up, we've bought property. Plan for our property, and we have a plan for our children, a legacy for our children. We own 2 individual quarter-acre lots, for example, in Key Largo. These are scarified lots, buildable lots that have no environmental implications to anyone. We are literally 13 miles from the county line, so we're in an area where we could evacuate very easily. And this was a dream for us to be able to have these lots, to be able to pass on to our children and our grandchildren. And now, hearing this today, I'm torn because I'm not ignorant. I'm very community in minded and community involved, and I see the issues with infrastructure. I see the needs that we have, but I also see a family that had a plan. We've done everything. We're not really impacting anyone in this at this point, and we stand the risk of not being able to build on 2 lots that don't really have an environmental impact as far as, woodedness, rats, whatever the issues of the other ones are, and we might not be able to see our dream become a reality. And part of this, yes, you've got to address, you can't just look at ROGO and all of this. You've let the TDC, and I've mentioned this in many, many meetings, you let the TDC go wild, and a lot of the implications that we're paying for, a lot of the things that other people are talking about and have noted in these conversations today have to do with the infrastructure. Yes, that's not.
Okay, do we have any other speakers?
There are no public speakers left.
Hello?
Oh. Hello?
Okay, this is Alicia Putney. I'm sorry. I've had technical difficulties.
All right, Alicia, welcome.
Good morning, Mayor and fellow commissioners. For the record, my name is Alicia Putney, and this morning I'm speaking for the Key Deer Protection Alliance. The Key Deer Protection Alliance has been active in growth management issues since before the adoption of ROGO, and actually participated in the passage by the BOCC of an emergency ordinance to put a stop to unbridled growth in the Keys while the ROGO was being crafted. It was an emergency situation given the number of projects in the pipeline back then. The ROGO has been a success for years. Ending ROGO is not a good idea. The question before us today is not how many ROGO allocations should we ask for from the state, but how many permits do we need to issue per year in order to continue to protect the future of the Florida Keys while limiting the number of takings claims. Issuing 6,000, 8,000 permits for the remaining buildable lots creates a serious problem with the issue of potentially ripe takings claims, because it could send the message that Monroe County has blocked the issuance of permits since 1992 for no good reason. We need to continue to issue a controlled amount of building permits. The only logical choice regarding the ROGO is to pass a revised version of a point assignment system. To do otherwise is a mistake that would destroy the remaining environmental attributes which make the Florida Keys unique and ultimately damage our economy beyond repair. Our recommendation is to craft a revised permit allocation system as soon as possible to ensure that nothing has changed to make it easier for someone to win a potential takings case against Monroe County. Throwing out the science, real-world evidence, and case law as bogus by releasing some form of permit allocation system needs to be adopted now. We recommend that the final ordinance be based on science, real-world evidence, and case law using the best available analysis. Separate from the revised permit allocation system, studies have shown that there are a shortage of affordable housing units that do not require issuing building permits. These alternative approaches need to be explored simultaneously with this issue. Thank you so much for your presentations, and thank you for your time and interest in this critically important decision.
And thank you for your comments. All right, Commission? We're going to have many, many opportunities to discuss this, so
Yes.
feel free to start it.
Madam Mayor, if I might. Yeah. So the questions that I have that I kind of discussed with staff that are going to be ongoing is, for any units that we do take, how can we protect those units to not turn into vacation rental units? And I hope we can use our power, and however it is, whatever the number is that we ask for when we sit with the legislative body, to somehow be able to preempt these or open up our vacation rental law and protect our existing stock and any new stock we would get. So that is, to me, one issue. I know, Bob, you just pulled your.
Yeah, this creates an opportunity to once again revisit the current preemption rules that prohibit us from changing our vacation rental ordinance. Without that, we can't.
Right. So that to me is a concern. And then the other one that I think we need to dive into more is workforce housing apartments versus single lots. And I feel like at some point we need to have that discussion. And that's what I have right now. I yield.
Excellent. Commissioner Cates, anything?
Yes, thank you. No, I thought this was very productive today, a lot of information. Obviously, you'll be waiting to hear from my constituents, and I have some questions I wrote down. It was a great first meeting.
It was. Commissioner Rice, anything?
Well, I think that this has been amazing. I think it's probably a comment on my sad life that I found it really, really interesting. Many of you have lived, and this is quite a process we've set out, and I'd like to commend staff for the work they've done in structuring our next, several months, 10, 12 months through December. It's an amazing process, opportunity to ask our questions, voice our opinions, anybody who cares will. And I agree with Alicia Putney, who, by the way, has certainly not gotten any dumber over the years. She gets it. It's not how many permits we take from Tallahassee. It's how we distribute them that matters. And I think we need to keep that in mind. We also need to deal with reality. We're not talking about 8,000 units anymore. That's now 2,220, if I remember correctly. So let's talk about 2,220. Suddenly became a much more manageable number due to Emily's findings that the remainder of those lots hopefully couldn't conceivably be built. So it's an important process. I commend everyone here today for their part in it. I think I will reserve my questions for the process, because I think it's important not to come up with answers at the beginning of the process before we have the information that the process will develop. I'm much more interested in solutions 6 or 8 months from now, because we'll know much more. Thank you very much.
Thank you, Commissioner Rice.
I keep thinking about, as we talk about the Florida Keys and the issues, but Kimberly, I don't know if FDOT is part of the team that is going to be part of the discussions, but certainly FDOT and anything we can do to alleviate traffic issues, any more units is something that's a critical element of all of this.
Okay. Awesome. This was an amazing process, Commissioner Rice, and I think today was extremely educational, and we do need to go to law school to learn about taking. Thank you, Derek, and that was incredibly complex and comprehensive. And just a shout out to Emily and Christine and Kimberly and everybody. I know a lot of hard work went into this, and Bob, and our clerks. I mean, it really is all encompassing, and as we map out our future as a community. And I think to use to finding that sweet spot between development and property rights, right? And what that looks like. And I think it's always good to find that balance and to strike that balance. And I think at the end of the day, that is what we will do. I know we will not make arbitrary decisions. We will have our strategic planner going out into the field for us. I think we're going to take a slow and measured approach. We're going to be extremely targeted. And we are going to have to consider infrastructure, traffic, our natural resources, our quality of life. With that said, just a couple housekeeping items. Lindsay's not here. Lindsay, are you back there? Or maybe Kevin, could you ask her to compile Emily's presentation, Derek's, and Kimberly's all in one email to be sent to us? We can have that information right at our fingertips and be able to share that. That would be extremely helpful. And I say that all to say, because Mary Claire Futch of the Department of Commerce checked in with me last Friday just to see how we were doing. And I was happy, and she was very satisfied to hear that we had a plan. I kind of walked through Emily's timeline. I let her know that our planning director was going to have numbers. We were going to have a primer, to use Mr. Wilson's word, on takings, and that we are moving forward collectively as a commission, as a community. So she would like to see those documents. I'm going to share them with her, and we will continue to keep the state updated, because at the end of the day, they are our partner in this. Half an hour break. We'll come back for our regular meeting at 1:30. And do I need to adjourn? More. There we go. I will entertain a motion to adjourn.
Move to adjourn.
All right. Second? Okay. Commissioner Lincoln motions to adjourn our special workshop on ROGO, and Mayor Pro Tem seconds. Motion carries.